a fair hearing. Are we ready?
Are we good to go?
Okay.
Thank you. So who asking the first question?
No, let me.
No, hold on.
Let me
We'll
start.
address you.
Okay, thank you very much. Well, today there were two applications before the court. The first application was an application for leave to file a supplementary statement of case, for leave to add an additional ground of review, and for leave to file further submissions in respect of our application for review. Now, that application was refused by the court. You heard the superior arguments of our counsel on the matter. Our counsel presented authorities, several of them, in which the court in the past has actually granted leave to applicants before the court to file supplementary statements of case. Our application was refused. Now, it's unfortunate that these rulings that are coming out of the court are so short. In the past, especially in 2013, we had detailed, reasoned rulings on why applications were either granted or refused. That has not happened this time. Now, when you examine or when you listen to the ruling of the court, the only reason they give is that the rules do not allow for it. So if the rules do not allow for it, why has it been permitted in the past? And so we think that the petitioner is not being treated fairly in these circumstances. And it's unfortunate, but we have to say it as it is. The petitioner is not being treated fairly. Now, counsel for the petitioner made reference to a specific case, Elistamaklo, in which that related to an application for leave to file supplementary. Now, that particular case, they were allowed to file a supplementary statement of case. The Supreme Court claims that it's distinguishable from this one. We disagree, because we believe that the intent of filing these supplements is to aid the administration of justice, but it was refused. Now, a second application, which was actually the application for review, which we filed in respect of the ruling of 19th January, that refused our application for leave to serve interrogatories on the first respondent's chair, that is Jean Mensah. That application was also refused. You all heard the very superior arguments of our counsel. He said there were fundamental errors with the decision. The fundamental errors he listed were: one, the Supreme Court said the interrogatories were not relevant. How can the Supreme Court say that in the light of the questions that we had posed in the interrogatories? For example, issues of transparency. When did Jean Mensah, for example, discover that she had made errors? When did she discover that she had made errors? What was the process by which she corrected those errors? Who did she consult in correcting those errors? Did she consult the agents of the candidates? And you will see, if you've seen our witness statements, the kind of activities that took place that day, where they sent the agents of the petitioner to go and consult with the petitioner on an issue, only to turn around and declare the results. This is what a chairperson who's supposed to be impartial, not be actuated by bias, this is how she behaved that day, and it's in our witness statement. How can anyone say that those questions are not relevant? Secondly, there was also a fundamental error in relation to the refusal to apply Order 22
Of CI 47.
of CI 47. Now, you are all aware that order by now, that order 22 of CI 47 relates to interrogatories. In 2013, there were no rules on interrogatories in CI 16, and yet the then petitioner, Nana Akufo-Addo, was allowed to serve interrogatories on the respondents. Nothing has changed except the passage of CI 99. Again, there's nothing in CI 99 that says that a petitioner cannot serve interrogatories. And so we disagreed with the court and thought that the petitioner has been denied a right to a fair hearing. And we referred to cases which said that if a petitioner, on grounds of expedition, is denied a right to serve interrogatories, that is a denial of a right to a fair hearing. And so we are saying that the refusal of our applications are not fair to the petitioner in the light of the past and in the light of what is happening now. So we disagree with the rulings of the Supreme Court. Unfortunately, that's their decision. There's not much we can do. We'll be in court tomorrow to start our case.
Thank you.
When they ask a question as to why can't we?
We have seen a witness taking down.
Well, of course, that's one of the reasons why we are saying that it's unfair to our clients. They have actually said, and you heard one of the questions that was put to the lead counsel, that if you can put those questions to the witness
During cross-examination.
during cross-examination. Now, the decision has said that those interrogatories are not relevant. If they are not relevant now, how can they be relevant for the purpose of cross-examination? We anticipate a situation where we will be stopped from actually asking those questions. And of course, it undermines our case.
You sound as though there was some grand scheme to frustrate the case of the petitioner. Is that your...
Not speaking about any scheme.
I haven't spoken about any
We
scheme.
leave that to the public.
I'm talking about our experience in the... Of course,
And our disagreements.
You said
yes.
the court had not been to the petitioner. You also said that in 2013, in the case that the then petitioner Nana Akufo-Addo brought, even though there were no rules guiding the service of interrogatories, he was allowed to do so.
Answer that question yourself.
I'm sorry?
Answer the question yourself. Was it fair? Is it fair? I will leave that to you to decide, and the Ghanaian public to decide. So you tell me, was it fair?
Any other question?
Any other question?
Looking at your claims of unfairness against the petitioner, do you still believe going forward that the court will be fair to you, or would you decide to withdraw your case?
We are not withdrawing our case. We will continue with the case. You will all see what will happen in the Supreme Court.
The court of public opinion.
Are we done? Okay. Thank you.
Thank you very much.
I'm doing it.
Okay, you sit down.
Let's take this back. Mbamcho etiawa mu no nia esi enne no eye areho asempa na esi ensem mienu ene eda court n'anim enne na edikan se omma yenkwan na yemfa another ground enka ye review na ye ka sanke pe no court no call etu agina bae no ombetugoyi ye tosimienu se review na nkase nemu ankata mu hu ensem a ye lead counsel chachuchi kata ode to ho ensem akase ni quotations ni emra oprugu ho at the end of the day court say on yen enya adwen enti sansem mienu ni na court etuagu na ne awreho wo mu ni se as otwitsere mienu sensene so yi ba ko nya ba ko 2013 na Akufo-Addo petin ya o yes obebi sansem bi ye man kwa mo obi sansem no eden na aba na John Muhammad opese obisa court so man kwa no omisa enu ni asembisa kase eda ho a yen adwumu de court na buade ba ye no mo nya adwen ni omo kai ni na entoyasum ye no mo nya adwen na so no so ntresa asem no ye nkoso nka ye bekoso akasem no tira mo behu ye court ye bekoso akasem no akosi bebi ebesie ese nia opam no onyina ya wo ye pam no wonyina ye damasipi.
Thank you.